Some crimes are so heartbreaking or shocking that they change laws, change society, or even earn the label crime of the century. But the stories that made headlines in decades past aren't necessarily remembered today. I'm Amber Hunt, a journalist and author, and in each episode of this show, I'll examine a case that's maybe lesser known today, but was huge when it happened. This is Crimes of the Centuries. The world is full of contradictions. Clarence Earl Gideon became one. Anthony Lewis, a New York Times reporter who followed his case and wrote the bestseller Gideon's Trumpet, explained,
He was a beaten down 50-year-old man who looked like he was 75 and had the worst of life. That's what he looked like. That's what he was.
Unschooled and unsophisticated, poor and unusually unlucky, the middle-aged drifter had already served some time for 4 felony convictions when he stood in a very warm Panama City, Florida courtroom on August 4th, 1961, and told the judge he wasn't ready to go to trial on felony breaking and entering and petty larceny charges. In a CBS News reenactment, I guess that was done when TV was in its infancy, Gideon and the trial judge, Robert McCrary, read the words they spoke that day. Weird, but here we go.
What says the defendant? Are you ready to go to trial?
Your Honor, I'm not ready for trial.
Why aren't you ready?
Because I do not have a lawyer.
Don't you have a lawyer? Did you not know that this case was set for trial today?
Yes, sir, I'm trial today.
But if you knew your case was set for trial today, why did you not secure counsel and be prepared to go to trial?
Because I'm without funds to hire an attorney. Your Honor, I'm going to ask this court to appoint me counsel representative.
It's a little hard to make out, but Gideon explained to the judge he didn't have the funds to hire an attorney. So he requested the court appoint him one. Judge McCrary apologized to him but said that under the laws of the state of Florida, he couldn't do that. The crime Gideon was charged with wasn't a capital crime, the judge explained, so no, the state couldn't provide him with any legal assistance.
Well, the United States Supreme Court says I'm entitled to counsel.
The judge knew that the Supreme Court guaranteed no such thing. But he did ask the court reporter to note Gideon's request and also note that it had been denied per Florida law. The record also noted that the name of the highest court in the land had been invoked, albeit incorrectly.
To me, that was just common sense. There was no argument to it. It just wasn't a belief to me. I mean, it was just something I know is right.
The trial then went on with Gideon doing his best to defend himself. His best lacked the kind of incisive reasoning that defense attorneys are noted for. He had not really understood his right to question the jurors about their biases before agreeing to their inclusion on the jury that would pass judgment on him. He hadn't asked any follow-up questions of the primary eyewitnesses that might have challenged the prosecution's case. He offered no alternative scenario for how the crime had occurred. He had no strong character witnesses. He had just his own word that he didn't do it. He did not take the stand to expound on that. It's true that he had been in a few courthouses and watched a few trials in action as they concerned his own guilt, but watching a trial ain't law school. It isn't even close. No surprise then that it didn't take long for the jury of 6 to find him guilty and the judge to sentence him to the maximum allowed, 5 years in prison for something he swore he did not do. To say that injustice ate at Gideon would be wrong. It consumed him.
It makes no difference how old I am, what church I belong to, if any. The question is very simple. The question is, I did not get a fair trial.
Raised a God-fearing man, he knew who he was. He wasn't proud of a lot of it. He knew that he had not lived up to his parents' expectations. His brother and sister did, he would later write, but not him. He wasn't the best father, nor a particularly good provider. He was, he wrote, what he called an individualist, someone who had to make their own way. And he had been, and was still willing to do that, even in the hardscrabble world in which he had thrown himself when he was just 14. He might have had an 8th grade education, but he understood fair. When he did wrong, it was fair that he was punished. But this conviction, well, this was most certainly not fair. And if he'd been wrong about the Supreme Court guaranteeing him a lawyer, well, he'd let them know they were wrong, because he should have had one. There had to be a way to tell them that, he figured. He'd find it. How Clarence Earl Gideon went about proving that ensured all Americans a right we now take for granted. Crimes of the Centuries is sponsored by Uncommon Goods. Spark something uncommon this holiday season with incredible hand-picked gifts from Uncommon Goods. They make your holiday shopping stress-free by scouring the globe to find original, handmade, and seriously remarkable things for everyone on your gift list. Whether you're shopping for your secret Santa or your entire family, Uncommon Goods knows exactly what they want. I love the stuff I found at Uncommon Goods. They've got the cutest outdoor decorations. I just ordered a wind chime that looks like an owl. It's just one of those quirky, fun things that makes me smile when I see it. Plus, I'm setting up camp on the site to find holiday gifts because, crazy as it sounds, that's right around the corner. Uncommon Goods looks for products that are high quality, unique, and often handmade or made in the U.S. They have these meaningful, out-of-the-ordinary gifts that feel personalized, plus some gifts that you actually can personalize. My favorite part, though, is that when you shop Uncommon Goods, you're supporting artists and small independent businesses. Many of their handcrafted products are made in small batches, so shop now before they sell out for the season. To get 15% off your next gift, go to uncommongoods.com/COTC. That's uncommongoods.com/COTC for 15% off. Don't miss this limited time offer. Uncommon Goods. We're all out of the ordinary. Clarence Earl Gideon was born in Hannibal, Missouri in 1910. His father died when he was 3, so he had no real memory of him. His mother remarried a hard-working fellow shoe factory employee. Gideon said both parents, quote, lived by the best moral customs, end quote. Most of what follows about his life before 1961 comes straight out of his November 1962 letter to his lawyer Abe Fortas, when Fortas asked for a biography of sorts so he could get a feel for the man and his circumstances. None of it was ever contradicted by other people or other documents. Gideon figured he was the cause of most of his parents' arguments, so he left home at 14 to make his own way, getting all the way to California before circling back to the Midwest. His year away, wandering around, learning the ways of the world, riled his mother, who immediately had the authorities put him in jail. Nice. The next day, he found a way to escape that podunk jail, but being as this was in the dead of winter, he needed some warm clothes if he was going to get very far. He broke into a store and helped himself. He was not out long. The next day, wearing everything he stole, he was arrested and, at the request of his mother, sent to reform school where he frequently ran afoul of authorities and was regularly beaten, and had the scars to prove it. When he got out, he got a job at the same shoe factory where his parents worked. His wage was $2 a day, and then he married before he turned 18. But things, as they're wont to do, fell apart. He lost his job, had to find some money, and figured burglary was the easiest route. That earned him a 3-year stay in prison, only to be paroled in the middle of the Depression, when even the educated and those with clean records couldn't find work. He would later write that he lived by his wits, which meant really that he stole when he had to, and from what I can tell, he wasn't all that good at it, because he spent some of the rest of the Depression in both federal and state prisons for various odd thefts, which netted him not much except the food and shelter that prisons do. Since these were bad years for most everybody, he might have done himself a solid there. Anyway, when he escaped prison in 1940, he faked a draft card and landed in Houston under the alias Barney Smith, but was fingered as a fugitive 4 years later thanks to his picture appearing in True Detective magazine as a wanted man. See what I mean about unlucky? I know this little litany of woe doesn't speak well for the man. The next few years don't do much to elevate that opinion. He went back into prison, back out, back in, back out, landed in Orange, Texas, just a few miles from the Louisiana border. He got married and divorced twice, got married again, bought a pool hall, lost it, worked on tugboats, fathered 4 children, supplemented his income by gambling regularly with the chief of police, who eventually arrested Gideon, after some heavy losses of his own, for breaking and entering. Clarence Gideon was not a paragon of virtue. His family believed he was hardworking and only stole when other means failed him. Never took a lot, never stole from widows or orphans, wasn't dangerous, just liked to drink and gamble, and because of that, got tossed around in life. And because Gideon had few resources to bail him out of all this handmade disarray, things got worse. With him in jail, the wife had to find work and the children were left to fend for themselves. Soon enough, his children were taken by welfare agencies and placed in foster homes, which broke his wife body and soul, and then all kinds of church agencies and welfare agencies and adoption agencies got involved, and the wife was in jail for drunk and disorderly behavior, and Gideon was out, then went in again on some loitering charge. The family he had was laid to waste. That catches us up to June 3rd, 1961, more or less, when Gideon lived by himself in the Florida eastern coast burg of Panama City, in the seedy Bay Harbor Hotel across the street from the Bay Harbor pool room. It's here where a young man named Henry Cook would relate the events of that morning as he said he remembered them. Cook had been at a dance in Apalachicola about 60 miles from Panama City, and some friends with an old Chevrolet had driven him back to the pool hall. Around 5:30 a.m., he said he'd seen Gideon smash a window and then watched as Gideon walked around inside the closed hall, stealing a dozen bottles of beer, a dozen Cokes, some wine bottles, $5 from the cigarette machine, and $60 from the jukebox. Those last 2 items were decidedly heavy, going as both machines took coins, which meant Gideon would be hauling a serious weight of silver around in his pockets when he was seen leaving the premises by Cook. Cook said Gideon then took a cab and hightailed it out of there. Cook didn't call the police. He hung around long enough for a sheriff's deputy to roll up later that morning and spot him standing by the outdoor phone booth. The cop asked Cook what he knew about the broken window over there at the pool hall, and he told what he said he'd seen. Gideon would be found drinking beer in another Panama City pool hall that very day with a big wad of nickels, dimes, and quarters in his pockets. Here's Gideon talking.
It was on Saturday, I believe, when I was arrested, and I was arranged, and they give me a preliminary trial the next day on Tuesday. And that was the first time I found out the actual direct evidence they had against me of breaking into this place here.
You know what happened after that. The trial went badly. The cab driver who picked Gideon up at the pool hall said he was paid in random change and that Gideon had said, quote, "If anybody asks, you haven't seen me," end quote. It didn't take long before Gideon was packed away to North Florida to the state prison at Rayford for a while. And man, oh man, was he pissed. He could read, though, and he could write, if not well, then some, and was fully prepared to use his most powerful weapon, a pencil. Now, Rayford Prison at the time, according to the New York Times' Lewis, was no hellhole. It had lawns and landscaping. Prisoners got to walk around at will when not working or before meals. They could smoke and read in the open air. They could converse with each other. Like all prisons, it contained a law library, and it stayed open late if you asked nicely. And Gideon got to work figuring out first what he had to do. He boiled that down to 3 steps. He had to petition the state for a writ of habeas corpus, which meant that the state had to explain why he was being held. Then he had to ask the Supreme Court of the United States for a writ of certiorari, which basically asked the justices to hear your case. He also had to send them an affidavit, something called an informa pauperis application, that explained that he could not afford to pay court costs or fees. Already in his way were 2 big obstacles. One, the Supreme Court, over time, just has not been eager to require the states to apply the specific criminal law guarantees set forth in the Bill of Rights. That is, states pretty much had the independence to frame their own criminal law procedures. You didn't have to have a trial by jury, for example, and that whole illegal search and seizure rule? Nah. And 2, there was already a precedent in place that said something about requiring legal counsel for a defendant. It was part of a 1942 case referred to as Betts v. Brady, in which the court ruled that the states had to appoint an attorney to a defendant if he or she were illiterate, incompetent, crazy, if the case included very complex issues, or if there was special circumstances to be considered. And all that necessary paperwork needed to be typewritten, something the prisoners at Rayford did not have access to. So pencil would have to do. That first obstacle was mutable, which Gideon figured was the case, though maybe he wasn't so sure what mutable meant. Secondly, they had already decided this thing, and he didn't fit any of the exceptions. He was asking for more, if you'll recall.
This is the essence of what Gideon wrote. This is a quote. "The question is very simple. I requested the court to appoint me attorney, and the court refused."
Is that how the system was supposed to operate? Crimes of the Centuries is sponsored by Ibotta. You know the holidays are coming, and traditions are what the season's all about. This year, start a new tradition with Ibotta. Ibotta gives you cash back on all your purchases so you can keep those holiday traditions alive no matter how old or new. Now, let me tell you about Ibotta. It's a free app that lets you earn cash back every time you shop. You can earn hundreds of items from groceries to toys to tech. The average Ibotta user earns $256 per year. Think of how much extra holiday magic you can make this season with more room in your budget. With Ibotta, you earn cash back that you can withdraw to your bank account, PayPal, or gift cards. Simply add offers in the app, upload your receipt, and voila! The money is yours. Plus, with Ibotta, you can save on over 2,400 brands and shop at over 1,000 retailers, including your favorite grocery stores, or maybe Lowe's, or Macy's, or Sephora, or Best Buy. Right now, Ibotta is offering our listeners $5 just for trying Ibotta by using the code CENTURIES when you register. Just go to the App Store or Google Play Store and download the free Ibotta app to start earning cash back and use code CENTURIES. That's IBOTTA in the Google Play or App Store and use the code CENTURIES. Crimes at Centuries is sponsored by Smalls. If you're a longtime listener, you know that sometime last year a certain someone entered my life. Let's not talk about him right now. Let's talk about the cat he brought with him. Sister Betty Lou is now a full-time resident of the Hunt household, and I'm in love. If you're curious about the origin of her name, she's a reincarnated nun. That's according to the shelter from which she was rescued. Now, Sister Betty Lou has some skin issues and occasional tummy troubles that we were hoping Smalls Cat Food would help with, and it has, which is why I'm thrilled to have Smalls back as a sponsor. Smalls Cat Food is protein-packed recipes made with preservative-free ingredients you could find in your fridge. Betty likes all the flavors, so I can't really tell you her favorite. More importantly, though, her skin feels clearer when she eats it, and that's a big deal because she stops making muffins when she's itchy, and it's just too adorable when she makes muffins. We all want our cats as healthy as possible, and after switching to Smalls, 88% of cat owners reported overall health improvements. So give your cat the gift of great cat food this holiday season. Head to smalls.com/COTC, use promo code COTC at checkout for over 50% off your first order, plus free shipping. That's the best offer you'll find, but you have to use my code COTC for 50% off your first order. One last time, that's promo code COTC for 50% off your first order, plus free shipping. If you've heard of Chief Justice Earl Warren, it's probably from his famous report on President Kennedy's assassination. But of course he was involved in much more than that during his 16-year stint as head of the U.S. Supreme Court. His court would be responsible for civil rights and constitutional guarantees being expanded and enforced as it dealt with school segregation, interracial marriage, the one-person, one-vote legislative mandate, and police procedure. Before I continue, I want to make a point here. Chief Justice Warren was the driving force behind something called the Constitutional Revolution, with his court changing America, making it more fair, more open, more reminiscent of what the Founding Fathers had envisioned in their dreams of a great nation. He was a Republican, a former governor of California who would have been vice president had Thomas Dewey beat Harry Truman, which he almost did. Abraham Lincoln would have loved him, but I digress. Now, I love how the sausage is made, explainers, but not everybody does, and I'll honor that. Let's just say Warren's clerk read what Gideon had written, wrote a memo or two, talked to Warren, who talked to his colleagues on the court, and because not everybody was fond of the limitations put down by Betts, they agreed, well, okay, let's hear this thing. One of his esteemed colleagues on the court was Justice Hugo Black, who had been spoiling for this fight, former Solicitor General Paul Clement.
Truth be told, from a certain point of view, if Gideon hadn't been the vehicle or instrument for this Supreme Court ruling, I do believe that some other litigant would have been, because there are larger structural forces at play in the development of the United States Supreme Court's case law that made this the right time for the court. The court was looking for a case like this one.
The state of Florida got its turn to explain to the court in a formal written response that they had, in good faith, just followed the rules laid down by its legislature. The old "we did nothing wrong" response. Maybe we should discuss that, the justices responded. Then the Supremes assigned an attorney to argue Gideon's case in front of them. They were not willing to let Gideon represent himself here, of course, but he could have pulled a much shorter straw than the one he did. They asked a lawyer named Abe Fortas to be Gideon's counsel. Abe Fortas was no slouch. He was, wrote reporter Lewis in his book, quote, a high-powered example of that high-powered species, the Washington lawyer, end quote. His was a smallish law firm, too aggressive to be an establishment firm, too casual to be considered stodgy, but mostly made up of Yaleys, products of a law school that regarded law as a social tool. Constitutional scholar Akhil Amar explained the choice.
They wanted to make sure that they were hearing the best arguments on both sides.
Fortas was wicked smart, loved good art, married an expert tax attorney, and lived in the D.C. enclave of Georgetown. He understood power, but he also understood the law and the court and how all that stuff worked. Not how it pretended to work, but how it really worked.
I received a call from the clerk of the Supreme Court telling me that the court had designated me to act as counsel without fee for Clarence Gideon. At the time, I knew only that Gideon had been convicted of a felony in the Florida state courts, and that the issue involved was the right to counsel.
The first thing he did, which I know you've already gathered, was ask Gideon to give him the story of his life. They would do this by letter. Truth was, Fortas had to make sure he was representing the man, Clarence Gideon, and not the principal. Because that's his job as a defense attorney. It's not to change laws. It is to represent a human being and to do this to the best of his ability. He had to make sure Gideon wasn't illiterate. His letters proved him capable there. He had to make sure Gideon wasn't crazy. No court had ever assumed so. So okay, he was free to take on the case, to say that Gideon didn't meet Florida's specifications for a lawyer, but he deserved one because everyone deserves one. In fact, in 1963, when the case was about to be heard in the highest court in the land, 37 states provided counsel to indigent defendants in all felony trials. 8 more did so as a matter of common practice. The remaining 5 had no provision for counsel except in capital cases. Fortas saw the way the states had been bending. That was promising. But it didn't change his fundamental zeal for asking the court to overcome its reticence and be the light in the darkness of the world when it came to justice. He would claim it was the only decent thing to do, the least a civilized country could do to ensure the rights of the accused mattered. That we were not, like in the not-too-distant past Nazi Germany, which had allowed no one to speak in their own defense. He'd argue we were better than that. The state of Florida was represented by a 26-year-old assistant state's attorney named Bruce Jacob. His first mistake was asking the attorneys general of all 50 states to write an amicus brief to the court defending the states' rights point of view being challenged here. The Attorney General of Minnesota at the time was a man named Walter Mondale. He would later become vice president under Jimmy Carter and also was the Democratic nominee for president in 1984, nominating Geraldine Ferraro to be his running mate. Anyway, Mondale decided to rally the other attorneys general and write en masse in support of Gideon. Here's Mondale.
We decided to solicit those same attorneys general on the side of an amicus brief that would say it should be a national legal principle that right to counsel should be provided. We got a lot of support for it. This was new. This usually didn't happen. States would just duck on issues like that. In this case, 22 states said, no, this should be changed.
Only 2 states chose to express their support for Florida. Still, Jacob's job, very explicitly, was to speak for the state and for the upholding of its legislature's intent. He did that job very well.
We argued in the United States Supreme Court that historically the Sixth Amendment right to counsel meant only that you had the right to have counsel at your own expense. It did not include the right to have counsel appointed for you at state expense. We pointed out further to the Supreme Court that throughout history, the states have always had the power to enact or adopt their own rules of procedure in criminal trials. And we said that if they should require an absolute rule, if they should adopt an absolute rule requiring the appointment of counsel in all criminal cases, this would be intruding upon an area traditionally and historically reserved to the states.
That is, he made a very clear case that there was no requirement in his state to give Gideon counsel, that in fact there was no historical precedent for that Gideon had participated in his own defense, that the judge had even tried to help him. He added there were thousands in the state's prisons who had not had counsel, and what the hell would happen to them if Gideon won his case? He argued that the ensuing chaos would prove an undue burden on the state. And where would the helping end? Expert witnesses? Forensic testing? Good God, we're talking about gazillions of dollars here. The court interrupted at some point, the trial transcript doesn't indicate which justice spoke here, to point out that in one of the state's briefs, it was noted that the state currently had 8,000 prisoners, 65% or 5,200 of whom had been tried without counsel. Later, the court asked another question. Were any of those 5,000 illiterate? The state's attorney couldn't say, but he imagined so. It was now Abe Fortas's turn again, who, in his final remarks, reminded the justices of a crime that allegedly occurred in the early 20th century, a jury bribery crime adjacent to the Los Angeles Times bombing case.
As I later said to the Supreme Court upon argument of the case, I remembered that when Clarence Darrow, one of the great criminal lawyers of all time, was accused of crime, he immediately went out and hired a lawyer to defend him.
If Clarence Darrow needed a lawyer, he argued, so does everybody else. Then, and only then, would due process be fully realized as the promise of the Constitution. The justices weighed the arguments and found that the Sixth Amendment did in fact guarantee a right to counsel when they unanimously sided with the uneducated white guy accused of stealing 2 six-packs of beer and some Cokes from a Florida pool hall. Associate Justice Hugo Black spoke for the court.
From the very beginning of our nation, we have laid great emphasis on fair trials in which every man stands equal before the law. This noble ideal cannot be realized if a poor man charged with crime has to face his accusers without assistance. The right of a man to have a lawyer may not be considered essential in some countries, but it is in ours.
Gideon later remembered learning the news.
Well, I felt great because I was listening for the decision on the radio. When it came on, most of the prison population heard it. You could hear them holler for 10 miles, I suppose, from there.
He was glad he won, but he was not thrilled with the flip side of his conviction being overturned. It meant he'd have to stand trial all over again. Gideon claimed it was double jeopardy. No, the legal minds explained, if you get a new trial in this or any appeal you instigated, that is not being tried twice. It is being tried once with new appellate place parameters in place. Gideon was not appeased. Didn't sound right to him. He walked out of Rayford State Prison, as did several others who immediately were recognized as those who had been incarcerated without the benefit of attorneys and who did meet the illiteracy or incompetency standards that Betts v. Brady had already granted them, but that they hadn't benefited from. Gideon went back to Panama City. The American Civil Liberties Union offered him 2 attorneys to help him with his case. He told Judge McCrary, the same judge who had heard his original trial for this crime, that he most emphatically did not want the ACLU lawyers. He'd take his chances with Fred Turner, a local lawyer who knew the people there, knew the town, and that he, Gideon, could talk to. Offered an additional lawyer to help Turner, Gideon rejected that too. The man was a stubborn mule, truth be told. He just was. The second trial began August 5th, 1963. In addition to the prosecution, who had already tried the case once, also on board were another assistant state attorney as well as his boss, the state attorney for the circuit. Turner called the eyewitness, Henry Cook, to the stand. And pretty quickly, Turner began to attack the original story. Who were the guys he rode with? Cook couldn't remember. Why had they been happy to drive him 60 miles back to Panama City, but left him 2 blocks away from his house at a pool room? Cook mumbled a weak response about how he wanted to frequent the bar when it opened at 7 a.m. Turner suggested maybe Cook and his buddies had taken the beer while they waited. He then asked Cook how he could see inside the pool room when the windows had been covered over with placards and were pretty high to start with. And, asked Turner, is it correct you didn't call the police? You waited until they made their rounds and came up to you to ask what you knew? That's correct, said Cook. Did you tell this court that you'd never been convicted of a felony? Well, yes, he had said that, but he'd been convicted of stealing a car but got probation, so he didn't think that counted. That didn't sit real well with the prosecution, but there it was. When it was Turner's turn to call witnesses, he called the cab driver who said that Gideon always carried a lot of change. He ran a gambling game in town and the stakes were nickels, dimes, and quarters. He also said Gideon always, as a matter of course, told him not to tell anyone he'd been in the cab. Wasn't anybody's business. Turner asked, did Gideon have anything with him when he got in the cab at 5:30 a.m.? The cabbie said no. No dozen beers, no dozen cokes, no wine, no jangling pants. Then Turner called the pool room owner. Did Gideon sometimes help out at the pool room? You know, cleaning up or opening for him? Yes, said the pool room owner. The implication was that Gideon was trusted in that pool room to not steal beer, which Gideon drank, or wine, which he did not. In summing up, Turner suggested that Cook had manufactured the story about Gideon because he and his buddies had done the crime and found an easy scapegoat when Gideon stepped out of his ramshackle hotel and walked across the street to call a cab. That he had made a hard-on-his-luck man go to prison for something he didn't do. Something that Henry Cook, of all people, knew goddamn good and well he didn't do. Gideon was found not guilty.
Through Mr. Turner's efforts, the evidence was so simple that it had been impossible for me to have committed the crime.
Turned out, he did need a lawyer, and as Lewis later wrote, he probably needed Fred Turner, a guy who knew what went on in Panama City, a well-known criminal defense specialist who had represented Henry Cook in a divorce case, a battery case, and for stealing $1.98 from a drunk. Together, Gideon and Lewis made sure that everyone in America would forevermore have the right to counsel in criminal cases. Crimes of the Centuries is sponsored by Miracle Made. I put on my bed a brand new set of Miracle Made sheets, and I already love them. I can't wait to slip into them tonight because, as gross as it is to talk about, the fact is that traditional bed sheets can harbor more bacteria than a toilet seat, but Miracle Made offers a whole line of self-cleaning antibacterial bedding that prevent up to 99.7% of bacteria growth and require up to 3 times less laundering. Here's what else I love about these sheets. They have temperature-regulating properties for better quality sleep. Miracle-Made sheets are thermoregulating and designed to keep you at the perfect temperature all night long, no matter the weather. Go to trymiracle.com/COTC to try Miracle-Made sheets today. And whether you're buying them for yourself or as a gift for a loved one, if you order today, you can save over 40%. And if you use a promo code COTC at checkout, you'll get 3 free towels and save an extra 20%. Miracle is so confident in their product, it's backed with a 30-day money-back guarantee, so if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/COTC and use code COTC to claim your free 3-piece towel set and save over 40% off. Again, that's trymiracle.com/COTC to treat yourself. Thank you, Miracle Made, for sponsoring this episode. What the Warren Court would go on to do after its ruling in Gideon versus Wainwright in 1963 was rule in Miranda versus Arizona in 1966 that it wanted to see inside America's police stations, its courthouses and jails, and be assured that the accused were treated safely and fairly. Later courts would require even more oversight, such as dashboard and body cameras on arresting officers. Abe Fortas was the same age as Clarence Gideon. Before the two men met, Fortas worked in FDR's Department of the Interior, was an advisor to the Securities and Exchanges Commission, and taught at Yale Law School. He was appointed to the U.S. Supreme Court by Lyndon Johnson in 1965, but only served on the bench for 5 years. His nomination to be elevated to Chief Justice ran into some Republican roadblocks, and he retired from the court in 1969. Bruce Jacob, the Florida Assistant Attorney General who argued that Gideon wasn't entitled to counsel, ironically became one of the country's most outspoken and prominent spokesmen for it. Though in retellings of this story he's often portrayed as overmatched by the erudite and experienced Fortas, Jacob was a highly competent lawyer who was given a tough hill to climb. He lost, of course, but when Florida was forced to comply with the Gideon decision ruling and enacted a law creating a statewide public defender office, he volunteered under the provision that stated lawyers in private practice could do the work unpaid if they wanted to. As an assistant professor at Emory University Law School, he established a program to provide free legal help to those in federal custody in Atlanta. He did the same for inmates in Massachusetts when he did graduate work at Harvard. Similarly, while teaching at Ohio State University, he created the Criminal Defense Clinic and the Criminal Appeals and Post-Conviction Remedies Clinics. He served as Dean and Professor of Law at Mercer and Stetson Colleges of Law. He's been given almost every award out there that honors criminal defense advocacy and for those attorneys to have reasonable caseloads to assure the quality of work they do. It was Jacob who told others that Fred Turner, Gideon's lawyer in his rehearing, told him that Gideon had more help in filing his original Supreme Court request than has been assumed. Gideon, apparently, had had a pretty famous cellmate at Rayford. He was a man named Joseph A. Peel, a former West Palm Beach Municipal Court judge who was convicted of plotting the 1955 murders of a higher court judge and the judge's wife in a scheme to become state's attorney, attorney general, and then governor of Florida. He dreamed big. Now, Peel had obviously gone to law school, which, I'm just guessing here, meant he knew better than to sell protection and accept payoffs for getting some offenders off, which he did much later admit to. He also later admitted to knowing that the higher court judge had found out about the goings-on in Peel's courtroom and was ready to report the lower judge to the bar. In a 1982 interview with the Miami Herald, Peel said he was guilty of a few less than savory things, but he was innocent of outright murder. The couple was allegedly drowned, though their bodies were never recovered. He did tell the paper he knew enough that he could have stopped the perpetrators from going ahead with the plan, but he didn't. He died of cancer 9 days after he was paroled. He never spoke publicly about Gideon, as far as I can tell. My point, of course, is that Peel was in close quarters with Gideon, and that's why the case was so clean, so perfect for this court. Specifically, that no special circumstances were ever alleged in his case. Jacob wrote, quote, "A lawyer such as Peel would have understood the Supreme Court was on the verge of overruling Betts, and that the perfect mechanism to enable them to do this would be a petition for habeas corpus alleging no special circumstances, a denial by state courts, and then a petition for certiorari alleging a denial of the right to counsel, but not alleging any special circumstances. Also, a lawyer would have been aware that Gideon lost nothing by shooting for the moon in this attempt." End quote. Which I guess means fate is funny, that bad things can bring about good results sometimes. According to the Department of Justice, 80% of all those who come into contact with the American judicial system cannot afford counsel. It is that important. Justice Hugo Black's law clerk, Dick Howard, knew it when he helped write the majority opinion for the court.
Gideon was the one that somehow went to the heart of the whole criminal trial process. Gideon was the embodiment of Hugo Black's argument that Bill of Rights guarantees ought to apply to the states. I knew as we worked on that opinion, here was one that was going to be in the case books as long as people study American constitutional law. This would be one of the big ones.
After the case was decided in 1963, 1,200 Florida inmates were released not to be tried again because they were illiterate, incompetent, or had circumstances which would have required the state to provide them with counsel. About 5,000 were retried. Clarence Earl Gideon was never arrested again. Hell, he may have given up the dishonest life as far back as 1951, and that was the date of his last conviction before he was charged with the Bay Harbor pool room crime. But that one doesn't count because a lawyer helped him be found not guilty of those charges. He pumped gas and fixed cars for most of the rest of his life, one surprisingly quiet, given all the brouhaha he caused. He died in 1971. He was just 61 years old. To research this case, journalist Amy Wilson read Anthony Lewis's Gideon's Trumpet, read more of When Law Fails, edited by Charles J. Ogletree Jr. and Austin Surratt. She read about the case on the University of Michigan National Registry of Exoneration's website, among others, and also read multiple retrospectives on the case in current and archived newspapers and magazines. She also enjoyed Gideon's Trumpet, the 1980 made-for-TV movie starring Henry Fonda. Crimes of the Centuries is available early and ad-free through Grab Bag Collab. Join us at patreon.com/GrabBagCollab to hear not just exclusive content related to this show, but to also get access to several other shows on our profit-sharing network. Unless noted in the citations, this case was researched and written by me, Amber Hunt, and produced by Amanda Rossman and Henry Lavoie. Original music is by Bruce Hunt, Andrew Higley, and occasionally by my son, Hunt Van Ben Scoten. Other music comes from Soundstripe and Epidemic Sound. If you like the show, help us out by rating and reviewing us on Apple Podcasts. For more information or to recommend a case, go to centuriespod.com. On Instagram, we're at centuriespod, and check out our Crimes of the Centuries podcast Facebook page.